Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years, your son has been arrested for 9 separate offenses?
9?
Yes, ma'am.
Arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games and I'm not going to accept the disrespect. Good morning. Are you Victor Charles Campbell Jr.?
Yeah.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
We are.
And it looks like we are going in 21-36426 and 22-39050, correct?
There's also a dismissal in 305.
All right, Mr. Campbell. In cause number 21-36426, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from November 28th of 2020. The indictment further alleges that you were previously convicted of assault family violence, a third-degree felony, December 5th of 2014. And how do you plead to that charge? So to the charge, let's start with just evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? It's guilty or not guilty. Either you did it or you didn't do it.
I thought that's what the plea was.
There's a plea agreement means in my court, you either enter a plea of guilty or not guilty.
Guilty. Okay.
Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I plead no content because he never even went over the indictment with me.
Yeah.
I find that hard to believe. So here's the
To
thing.
actually be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
Here's a picture
in both
one here.
Yeah.
So, the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from 2018, you have 5 years or 4 years to indict me to actually send that indictment. After
Sir, the
that's
allegation,
why I'm pleading no contest.
I'm not going to
I
allow.
find guilty. It's fine. Come on.
Here's the thing. I don't have to accept any plea agreement.
Yes, ma'am.
Okay. So you can, in that evading arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games and I'm not going to accept the disrespect. If you want me to follow this agreement and go along with the plea agreement and you can go on, do your time and be done with it, then we can get that done. But you're not going to show disrespect while we're doing it to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea agreement.
If you go to trial, listen to me. If
Yeah,
you go to
fine.
trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do, but you're going to either accept responsibility and plead guilty or plead not guilty.
Yeah.
That's your choices. So let's go back then and cause number 21-36426. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. You saying assault family violence. The invading arrest is I
Listen.
plead guilty.
It's evading arrest or detention
But
with
what
the
are you
use.
looking at? I'm saying
I'm
Look.
looking at your indictment.
He's saying you got indicted for
I got that.
evading. In 2014, you
Right.
were
Hold on,
convicted of
this,
something
Mr.
else. Okay.
You've probably already tried. Let me take care of it this way.
I-
Place that in front of your client, please. Now, that is cause number 21-36426. That indictment alleges in paragraph 1, that you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge?
I just pleaded no contest. She didn't want to accept no contest.
How do you plead to that charge? Guilty or not guilty? We're not going backwards, okay? I already told you you're not going to plead no contest.
Guilty or not, you plead guilty or not guilty.
So if I'm telling you no contest, what is that?
It's nothing and it's nothing. You're not allowed, I can take a plea of no contest or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again, guilty or not guilty,
I'm saying.
period. I'm
That's
about
saying
to
that
set
I'm
your
not-
case for
that's saying
trial.
that I'm not, that's basically saying that
We're not going to
guilty
argue the
or
law.
I'm not, or I'm guilty.
We're not arguing
That's
the law.
basically just saying that I
Doesn't-
state that.
I'm not going to
Go
argue the
ahead,
law
sign,
with
no
you.
guilty. Just sign, go ahead.
I
Put it
don't-
as guilty. Go ahead. That's what y'all want anyway. That's fine.
Listen,
I'm cool, ma'am. Just go ahead. and
well,
get
you're
the
not,
guilty.
you're really not being cool and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me the
It,
guilty.
nothing here.
Plead guilty. There you
Okay,
go.
so you plead guilty to evading arrest or detention
Yes,
with the
ma'am.
use of a vehicle. Okay. The next count, the next paragraph that you're looking at says that you were previously convicted of assault family violence, December 5th of 2014. Is that true or not true that you have that conviction
That's
on your
true.
record? Okay.
And that's not the same
That's
case
okay.
as far as
Look-
evading arrest, ma'am. That's two different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But
Exactly. And that's,
That's
listen, so Mr. Campbell, that's,
15.
wow.
I think.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, ma'am, I wouldn't mind.
I feel like I might because I'm not understanding. Mr. Campbell, you're getting a deal to go on count one only, which makes you a repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea agreement, it's repeat. I understand that. I've been doing this for 30 years. Okay? So, did you enter your plea of guilty freely and voluntarily?
Guilty.
Did anybody force you to plead guilty today?
No.
Okay, so I have well, let's go to the next case then. In cause number, and here's that indictment. In cause number 22 39050, you're charged with and in this case, we're just going on count one.
Count one only.
So in this case, we're going on count one only. So it's just the offense of tampering with physical evidence, a second-degree felony from November 28th of 2020. And how do you plead to that charge? Guilty or not guilty?
Pleading no content, but guilty now.
So are you pleading guilty to this charge?
Yeah. that's
Okay.
actually-
And did anybody force you to plead guilty in cause number 22 39050?
We just answered it.
I know I have to ask you in each case. It's required by law. It's required by law that I ask you that in every case.
Just pleaded guilty.
Okay, and nobody forced you to do that, right? Speak up so the record can take
No,
account.
I think you did. You did, but let's go. So no.
Okay, so I have in both of those cases here on the tablet, some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker?
Stuff we
The
signed.
documents on the tablet, y'all have that? And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving any right to appeal? Yes or no, please? Do you understand that?
Understand what we signed, the document.
Okay, you have to answer out loud, yes or no, so that the record's clear that you understand, that I know you understand what you signed, okay? I'm not trying to, doesn't have to be that difficult. Just get in, get your deal and get out. You're making this way more difficult than it has to be. Do you also understand, if you're not a US citizen, that a plea of guilty or no contest could result in your deportation? If you're not a US citizen, could result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
So what this is, I don't,
I'm required to ask everyone that. Are you a US citizen?
yeah,
Okay. State tenders number one in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Campbell is not competent?
No, you're not.
You said
I just printed the wrong thing.
She asked me if I thought that there's evidence you weren't. I said, no, there's not. He's confident.
I just printed the wrong stuff. Did I print both of the
Give him the
certifications?
thing on that.
Sure.
Please. Please.
Okay. All right, Mr. Campbell, I'm going to find in each of your cases that you, Mr. Campbell, pay attention to me for a second, please.
Oh, fell, please. I ain't drinking,
Mr. Campbell, ready?
Yeah,
In cause number 21-36426, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
so can you say that on record?
I'm on the
Yes.
record.
No, I'm saying say that, how long I've been in custody.
I don't know.
I've been
I don't
in
have that
custody going on
information.
5 years.
Okay, you'll get all the credit that you are entitled to get by law. And cause number 22-39050, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of tampering with physical evidence. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time and concurrently with any other sentence that you're currently serving. I have signed a dismissal as part of this agreement in cause number 22-39051. I'm handing you in both of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with your attorney. You can go back with the bailiff.
So do I get my papers for my time, sir?
Go back with the bailiff.
Is you gonna bring me my papers for my time,
They
sir?
have it at the jail.
Excuse me?
They have it at the jail. I told you.
You didn't tell me.
Well, he wasn't that bad.
I mean, this one might be difficult, and Judge, this one's really gonna
He-
push you over the edge difficult. Jonah Johnson, 25 DCCR 1775. It's not gonna take much for me today to lose my, I'm right on the verge. I am at my word limit.
Good morning, Your Honor.
Good morning.
I have one witness in this case. Your Honor.
Good morning. Are you Jonah Ray Johnson?
Yes, Mom.
And this is 25 DCCR 1775. Mr. Johnson is charged with aggravated assault with a deadly weapon. And Mr. Vasquez has filed a motion asking that I reduce Mr. Johnson's bond, which is currently set at $300,000 in that case. Are you calling your client?
Yes, Your Honor.
Mr. Johnson, best you can, raise your right
Oh,
hand.
no, I'm sorry, Your Honor. I'm not. I'm calling my client's mom, Jacqueline Broussard.
Ms. Broussard? Mr. Johnson, if you'll just come around just to the side, right there on the corner. Ma'am, if you'll come right over here, please. Good morning. And would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
Thank you. Ms. Broussard, state your name for the record, please.
Jacqueline Broussard.
And you've done this before, haven't you?
Yes, ma'am. Oh, sir, sorry.
And you are Jonna's mom, correct?
Yes,
And the original bond back in September was $150,000, wasn't that correct?
yes, sir.
And what went wrong? What was the problem there?
The ankle monitor, we thought it was broken, which that, we was led, that was, we called, Johnny and Johnny told us to come in. Which we had been talking with Johnny for 2 weeks. But like I say, Johnny said, come in, there's something's going on with the monitor. And we also was a payment behind.
Okay.
And, but we, like,
let me interrupt.
I'm sorry, go ahead.
That's all right. The bondsman said the defendant has failed to pay for the GPS device. It wasn't charged. He will not respond to surety's attempt to reach him. He cannot be located. Surety feels like his bond is at risk. Now, you disagree with that, right?
Yes, sir.
The bond was never at risk.
No, sir.
Jonna lives with you.
Yes, sir.
You live in Beaumont
Yes, sir.
with your husband.
Yes, sir.
And how many people live in that house?
Me, my husband, my oldest son, and Jonna,
And how long have you been in that home?
over 5 years.
And the four of you lived there.
Yes, sir.
Was Jonah working when all this happened?
Yes, sir.
Where was he working?
He was working for Jefferson nursing home.
Say again?
Jefferson.
What was he doing?
He was working in the kitchen.
And how long did he have that job? You recall?
I think he had just received that one over there, maybe 6 months. I'm not, yeah. Cause he just got hired out over there.
And he's 18.
Yes.
He lives with you. He's not. Is he a flight risk?
No, sir, he's not.
Are you worried about him taking off or running
No,
off?
sir, I'm not.
And you wouldn't waste your money if you.
No, sir. I wouldn't.
What bondsman have you talked to?
I had talked to a professional with Kenya, and I had talked also LRE with Lisa.
Which bondsman was this back in September?
I think that was Ella.
That was Ella.
Uh-huh.
Is that who you're talking to now?
Yes, one of them, yes.
And what have your conversations been like with them?
They just ready for me to get in touch with them and see if they're not gonna be reduced. I just had one text me this morning.
Have you talked to them about what amount you would want that you're trying to get reduced to? What would be reasonable?
At least 100,000. We had talked on that.
Well, it was 150,000 back then,
Yes, sir.
so it's not really realistic that that the court would drop to 100,000 now.
Mm-hmm.
Are you asking the court to reinstate I don't know if reinstate the correct word, but to go back to the $150,000?
Yes, sir. Yes, sir.
Is that something you think you could work with?
Yes, sir.
They probably want you to sign a contract for $15,000.
Yes, sir.
I think 10%
Yes,
is the one.
yes, sir.
Would you make sure there was no discrepancies or mistakes or misunderstandings about the GPS monitor system?
Yes, sir.
And what else would you like to tell the judge? About the bond?
Not the one. We are ready prepared to make fun. John.
Have you seen the video in this case?
Yes, ma'am.
Okay.
I have talked to my son. Yes, ma'am.
You've actually
And-
seen it?
Yes, ma'am.
Okay.
The whole video.
Okay. Anything else?
Nothing else, right?
That was
Questions of
actually,
this
that was
witness?
actually one of my questions I was gonna ask this witness, is whether or not she's seen the video, Judge.
Okay.
In addition to that, Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years, your son has been arrested for 9 separate offenses?
9?
Yes, ma'am. Evading arrest as a juvenile, UUMV as an adult, possession of a controlled substance, unlawful carry of a firearm, failed to ID, possession of a controlled substance, possession of marijuana, and 2 additional unauthorized carrying of a weapon. Were you aware of those arrests?
Yes.
Okay. Now, the gun that your son allegedly carried back on August the 31st of 2025, during that shootout at the Pine Club Apartments, do you have any idea where you got that gun from?
No, sir.
Are you aware that a bystander was shot during that melee?
Yes, sir.
All right, that's all I have, Judge.
Okay, any other questions of this witness?
No, Your Honor.
Thank you, ma'am. You can have a seat.
Thank you, ma'am.
Any other witnesses, Mr. Vasquez?
No, Your Honor.
Mr. Coleman?
Judge, one of the items of evidence that I plan on introducing was the video from the shootout. It sounds like the court vividly remembers that. So if the court doesn't wish to see that again, I want to.
I mean, let's just quickly play it. I want to I'm refreshing my memory by taking, well, first of all, I'm gonna take judicial notice of the court's file. I have reviewed the probable cause affidavit, which is what reminded me of the facts of the case, and I guess it was the other
It was the
case that we
co-defendant.
had a bond hearing on.
Yes,
Is
yeah,
that
yeah.
correct?
Well, no, I take it back. It was this defendant when he was represented by Brittany Holmes, if I'm not mistaken.
So I've had a bond hearing, watched the video on this case.
Yes, Judge, if I'm not mistaken. In fact, when you look at my notes, yeah, that would have been January 13th of 2026. My notes include that there's a defense motion to reduce the bond. We argued, yes, you heard evidence and testimony, and that you denied the motion back in January of this year.
So this was after the AFRS, and the bond was at 300,000 on that date for the same bond hearing.
Yes, Judge.
Yeah. Your
Yeah.
motion's denied. I've already
Yeah.
heard all the evidence.
Well, there is something, Judge, I think that it's at least, if you're gonna deny it, I think you may want to consider it as far as whether or not the bond is sufficient. As it states, it's just a 5-minute clip of
Go ahead.
a jail phone call that I've added subtitles to. If I could do that, I'm happy to bring my sponsor witness, but if you'll stipulate to it.
No, I'm gonna object to it to relevance. Your Honor.
Bring your witness, please.
Yeah. State calls Captain Michael Pond.
Good morning, sir.
Morning.
Thank you for your patience this morning. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes,
Thank you, sir. Go ahead.
Captain Ponder, would you state your full name for the record, please?
my name is Captain Michael Ponzer.
And Captain Ponder, very briefly, what do you do? What are your duties at the jail, over at the jail? That's your department.
I'm the custodian of records for the Jefferson County Correctional Facility.
And you're familiar as your custodian of record with the recording equipment there at the jail, correct?
Yes, sir.
And it's capable of making an accurate recording.
Yes, sir.
Each inmate is issued a unique identifying number, correct?
Yes, sir.
And that's one of the ways to identify who makes certain calls from the jail, correct?
Yes, sir.
Have you had an opportunity to review what I am marking? Judge, you want me to mark this as states 2 or 3? We entered one in the first hearing back in January. I can do it 1, however you want to do it.
I mean, it's technically a new hearing.
Okay, I'll do 1. Okay.
One's fine.
All right, you recognize this USB drive?
Yes, sir.
How do you recognize it?
Because I listened to it this morning.
And are these your initials in today's date that's on this USB drive?
Yes, sir.
I'm marking it as State's Exhibit number 1. You listened to it. Do you have any doubt that it's a fair and accurate copy of a jail phone call or recording of a telephone call made by an inmate, this inmate, from the Jefferson County Jail?
No, sir. No doubt.
All right, Judge, state off state.
Mr. Vasquez?
Good morning.
Yes, sir.
How long is this video?
This is
the
an audio.
recording,
It's
I'm sorry, the audio.
It's about a 5-minute excerpt from a 14-minute and 20 some odd second phone call.
Well, so it's been altered.
It's been included, yes.
Object to the alteration, Your Honor.
Judge, what's on here is the original 14-minute long video as well as the shortened 5-minute video with the subtitles added. So the original's on here.
Okay.
And by the way, I gave it to Mr. Vasquez yesterday, and he's had a chance to preview it.
States 1, with both, will be admitted.
Permission to post, Judge.
Yes.
Judge, can I finish my objection?
Sure.
There's a object to the alteration, and then there's a transcription. I object to that as hearsay. Where you're given
The subtitles.
the subtitles of what you think they're saying.
Do you disagree that the subtitles are correct with what you hear?
I don't know, Your Honor. I just object to it being hearsay.
Oh,
How is it hearsay?
The subtitles are on it to what they're, it's someone has written in what they've transcribed the conversation to be. I object to that as hearsay.
Mr. Coleman?
Judge, if the audio is not hearsay, which is a statement made by a party opponent, then the subtitles are therefore not hearsay. Judge, it's
I
just,
obviously will be able to listen myself and your objection's overruled. It's admitted.
Commissioner Buxton.
Yes, and that's both the excerpt as well as the entire and thank you, Captain Ponder.
Yes.
Maybe reported or monitored.
I gotta make it like she did 25. I said, this, he came back in, he said, like, we still ain't gave probation, the lawyer told them, do probation and shit, I was actually looking at the lawyer trying to ask probation and shit. She was like, man, there's too much shit been going on, it's like a wild west. You know, he told me, she was like, you got write-ups, you get jumping in, and that other shit, yeah. But she was like, I gotta make an example, but, oh my, man, crazy, people went crazy for me. Wow. No, he said people screaming that shit. They say, hey, world star type of shit. Bro, all over the world. Coming out of that, man. First, it was cool. We just chill. Kept like, bitch, you good, you good. Sure, you good, bitch, and they good. Like, I'm good with the whoop. So one day, just snapped. CO said something to him. They said, what is bitch had with the plate? So I get to the CO at night, want to punch him. They go, like, on 6 weeks. Ooh. Niggas, so he ain't trying to CO, ain't trying to punch that. Boom, he sniped the motherfucking computer. Punch that bitch. Break the motherfucking computer. They come, he been in the end door. Ever since they came out, I thought he been in the end door. That bitch 25 showers, but shit so good. Good. Hey, you ain't bitch. Anyway, you gotta do at least one. Yeah. I mean, I just. If you go down that trip, he gonna put it up for college for five. Yeah. And they go, it's his whole point. That's my little folks. Good ass question about. You want to leave your sentencing to the judge? And I said, hell nah. Take my shit to trial. I said, then boom, I got my bus for discovery. I seen all my evidence and shit. That shit bullshit, bro. Let me take this to trial, bro. They gonna drop the charge. So I took take the charge. Ooh, my lawyer's good. Now he looking at the paperwork and shit like, oh, you good? You feel? You give it some time. Like, I know it's gonna take time. Because everything that's going on right now, they ain't making it no better. My shit, but like I say, they come, even if they come like this, 5-year cap, they gonna say they off probation with a 5-year cap. I take that. I want to be careful. I want it 5 years. But if they do, I put like 2.5 on that bitch. Oh, come on, for a bank, you gonna have some bank time. Get fed. I'm gonna have some bank time. Sorry, I got 5 months bank time right now. You mean that 5 months, bitch? But it's like 5 months. 2 months I did, boy, this shit look like, very good point of the phone, but I think I really kind of been flying by. It is, once you get in, it's going to flying by. Sure. This shit, very vicious. So, man, wow, this is, I ain't in the mug, but this shit, very big. Something. And cause they've been around young, it's hard to do it. I out the way. But you know, push gonna come to shove, some shit gonna happen. Boom, you know. Get to the, like, that was my first write-up. Like, bitch, I've been chilling, so I've been quiet, doing that to nobody. That there's just write-up, got another write-up, I got fighting write-up, other fighting write-up. But I think they moved to this door. Shit. It was straight out to the top. So I do games that was going on, like shit. So, I guess it was my first came in, so I was a KO, boom. I said, it's coming to help leave and go back. There's gonna be a lot of niggas like this. I'm good. I'm like, hey, I can't back to this. Right? So, like, we got a oh, hey, let me get out this whole like, fuck, you see this, you know. So, I ain't gonna figure the world like this. It got to be good, yeah. And I also, yeah, shit, say, give that nigga probation for worse shit like that. Good, this is how I move. You come out on top with position probation for when you get a they just gave my other part of my free will part. They had 3 robberies. Hey, gave nigga ISL for 3 months and 10-year probation. That's like that nigga you can't believe. That's what I'm talking about. They gave ISL 3 months. 3 months ISL. He got 10 years probation. After he was already on probation for 10 years. But crazy, him and the dude that got us in the fight with the court the same day. You know.
That's all I have on that, Judge. State has no further witnesses.
All right, anything else?
No, Your Honor.
Okay. So at this time, I am going to deny the motion for a bond reduction. And I guess, Mr. Coleman, depending on any future incidents, if the state wishes to file a motion to increase, I would look at that at the appropriate time.
We have contemplated that, Judge.
But Mr. Johnson, a condition still, if you make that $300,000 bond, is that you would be on house arrest. You would be required to wear a GPS monitoring device at all times. Part of the reason that I'm doing this is because it sounds like you were working, your parents have the issues. I've looked at the bond, the affidavit for them to release surety. It's not just the GPS monitoring device. They obviously were having a hard time getting in touch with you for whatever reason. So I think that makes obviously one of the criteria under 17.15 for bail is that obviously you have to follow all of the rules and conditions of bond, which is with your bondsman as well. And so we will reset your case for an announcement, and Mr. Vasquez will visit with Mr. Coleman, get any offers in your case, and we'll either take a plea if you wish to take a plea at the next court date, or if you don't, we'll do a rejection and get your case set for trial. All right, you can go back with the bailiff.